Right now here on WHAS 11 Plus, it is coming to a close. The jury gets the case tomorrow after hearing closing arguments in the trial of the decade that's been underway in Kentucky, the Crystal Rogers case. Will Brooks Houck head to prison or be walking free? Hello, everybody, and thank you very much for joining us. For our 30-minute special report tonight, I'm Doug Proffitt, WHAS 11 News. Well, attorneys for Brooks Houck and Joseph Lawson argued today to the jury that there is no evidence linking their clients to the crimes. However, prosecutor Shane Young pushing back on that, pointing to cell phone data information and Houck's own written statement that they say is filled with lies. Let's go down to Bowling Green, Kentucky. Shay McAllister and Shay, Rosemary Houck, the mother, even showed up to the courtroom today. What was the atmosphere in the courtroom when they spotted her and they all walked in?
Well, Doug, Rosemary was one of the last people to walk into the courtroom, and this has been typical of the Houck family. They definitely haven't been congregating early. They've been shuffling in as everybody else has already taken their seats. Today, she was with her daughter, Rhonda's husband. She was with her boyfriend, and she also had right there next to her Crystal Maupin, who is Brooks' current girlfriend. I will say I don't think everyone noticed her when she walked in right away, as those of us in the front row, the journalists, did, but we certainly were aware of it because this was her first time in the courtroom over the last 2.5 weeks. This was her very first appearance, and of course she's coming in right as it's coming to an end, Doug.
With the prosecution in the case, Shay, as down there in Bowling Green, what is Shane Young hanging his case on right now as we had the closing arguments today?
Well, Shane Young really built his closing arguments over a timeline. He wanted to walk the jury piece by piece through all of the evidence they had heard, and he wanted to make it make sense to them. For example, spelling out why they heard from Brooks Houck's CPA, his accountant, who was the last witness to take the stand. Well, he reminded them that Crystal Rogers ran the rental business for Brooks Houck, and 1 week before she went missing, he met with his accountant to ask his accountant if he would take over the rental business. It was just a small thing, but it was something that I missed during the direct testimony, and it was Shane Young's chance to explain why he had those exact witnesses up and exactly what they had to offer. So what he starts with is a couple of weeks before Crystal goes missing. He mentions that meeting with the CPA. He mentions Rosemary's conversation with Danny Singleton, saying that was when this plan really started coming to life. Rosemary's asking one of Brooks Houck's former employees, "Do you know anyone who will get rid of Crystal?" Then he goes through that exact day. He talks about how on the day of July 3rd, Nick Houck's phone is off all day long. Of course, he's at the farm that entire day. Crystal Rogers is at Walmart this afternoon. He points out that between 4 and 4:43, Brooks is running errands. At 5:36, he is at home. His phone is at home. But then his truck is seen driving down the road. He said, I don't know where he was going, but he left his phone at home for that one. He talks about how Crystal's phone dies at 9:23. It pops back on at 11:57 and is quickly turned off. He said when Crystal was not home with him after midnight, he had to come up with a story for what she was doing. So he said, well, she usually plays on her phone. He said the prosecutor said that he used the word usually because he wasn't expecting that question. And because she wasn't there, he had to say what she usually does. Shane Young reminded the jurors that it's been 10 years last Friday that she has been gone. Shane Young said she didn't come home that day, and he, pointing to Brooks Houck, committed murder. This was interesting. He mentioned he's not sure who killed Crystal, but he believes that Brooks was a part of it. But he said, am I saying he killed her? No, I don't know who killed her. They keep going down this timeline, talking about all of the calls that Brooks Houck is getting. Crystal's family members calling and texting, asking, have you talked to Crystal? Do you know where mom is? And he doesn't respond or acknowledge any of them, but he does pick up a call from his own mother right during that period. He talks about how on the 4th of July, he wakes up and Crystal is gone, but he goes around business as usual. He makes breakfast, he gets dressed, he takes Eli back to the farm. They go to a 4th of July party at the farm, and that day he only calls Crystal twice and never gets in touch with her. So they're really just going through all of this evidence, painting a picture of what was happening and what jurors heard, but reminding them of why things are important. And there was a few key pieces of evidence that he talked about that really stood out. I'm going to bring in Alexandra Goldberg to walk us through that, because there was a few different things that were kind of aha moments.
Right, and Shane Young even naming the written statement. Remember that 8-page statement that took Brooks Houck about an hour and a half to write as the linchpin of his case. He says that he didn't mention that he went to the farm, although his phone is tracked to be there from 9:30 a.m. until about 4 p.m. that day on July 3rd. He said, well, he could have saved 5 pages of that statement if he were to just have written in that he went to the Houck family farm. But he says, quote, it's part of the deception. Shane Young saying that he's trying to throw police off course with this written statement, that the phone records don't match up with the written statement. He calls that the linchpin of his case. But there's some other large pieces of evidence here that Shane Young has tried to reiterate throughout the trial, and he is hoping that the jury is clinging on to this. One is those secret tape recordings. We know that some members of the Houck family had recorded the grand jury proceeding and also some of those police interrogations early on into, that first week that Crystal Rogers went missing. Well, Shane Young says that these recorders were purchased on July 6th. And he says, quote, these people aren't paranoid. They're trying to keep their story straight, trying to plead with the jury exactly why he believes some Houck family members had recorded both grand jury proceedings and police interrogations. Moving on to this white Buick, it's something that we've heard about time after time throughout the trial. Well, Young says, quote, they say it's because they didn't want it seized. I say it's because they didn't want it to be used as evidence. And to sort of back up here, we heard in the defense, we'll tell you about this in just a moment, that Brian Butler had said, well, Nick sold Anna Whiteside's white Buick just days after that Facebook post from Tommy Ballard because he didn't want to leave Grandma without a car. If police, were to seize that vehicle, well, it would have been out of Grandma's possession. Well, Shane Young says, nope, they just didn't want it used as evidence here. Doug.
Alexandra Shea, thank you very much. We want to go break down a couple of things that you all just talked about. Nick Mudd here with me, taking some notes on some of your key points. And WHS 11 News legal analyst, Louisville attorney Nick Mudd is back with us. He's been with us more than a year picking apart this case. Nick is a defense attorney, but he's also a former Louisville prosecutor who was with the Violent Crimes Division. First of all, I guess we should boil it down now the closing arguments are over. The key, most believable piece of evidence in this case, do you still put it right at the top, the cell phone data information?
I mean, absolutely, because there's not much you could do to undermine that. I know the defense tried, and I was curious how the defense was going to approach that, but Shane Young said it's important. I mean, he said it was key to the prosecution's case, and I think there are two things that are important, Doug. The first being the cell phone data, and the second, I have said, if Brooks Houck gets convicted here, it will be because he chose to talk to the police the following day. And Shane Young spent a significant portion of that closing argument breaking down that written statement, breaking down the things Brooks Houck told the investigator, and kind of going through and saying, look, he's a liar, and he's lying to cover up this homicide.
So in sort of the ping pong match here of the closing arguments, I want to go back to the 8-page written statement that Alexandra just closed with. Of course, this is Brian Butler, his attorney, Brooks Houck's attorney, bringing up the inconsistencies in the 8-page written statement to police, because we had all those people come on and refute every single thing that Brooks Houck had written in that. It took him an hour and a half to do it. And Butler said this, there's no way you could believe this is what he did. These were things he needed to do. None of this is incriminating if you put it in the light of that there's nothing at the farm. Of all of the counterpoints that he made, do you think that was convincing enough for the jury in that, or was he just sort of saying, you just sort of have to believe this?
I think he had to address it, because certainly Shane Young spent a lot of the trial refuting. The statement was played pretty close to the beginning. So I mean, we heard several witnesses, like the accountant and several other people, to just refute point by point by point by point in that statement to show how potentially had lied. So I think Butler didn't have a choice at that point. He had to come up with some explanation. He couldn't just leave it out there. And so I think he just did his best to kind of refute that and the most plausible explanation he could come up with, which is what you just said.
I thought this was an interesting tactic that played out today from Brian Butler, the defense attorney. I was wondering if you'd ever seen anything like this, where he actually, when he was talking about speaking to the jury, he said they looked for 10 years for a murder weapon. They found nothing. Arguing that the prosecution's case is full of reasonable doubt. If we're going to kill someone, there might as well be a doggone good reason for it. They gave you nothing. And then Butler plays a clip of the prosecutor, Shane Young, a video clip for the jury, where Young says, I don't know where she was murdered. Doing that well before Shane Young had his presentation. Have you ever seen anything like that happen before?
I tell you, Doug, and people need to understand what prosecutors and defense lawyers say is not evidence. It's powerful. Okay, it's convincing a lot of times, but at the end of the day, the opening statement, the jury selection, the statements that are made there, the closing arguments by the attorneys are not evidence. And so I think it was a gutsy move by Butler to do so. And certainly, obviously, he was doing his best to hold them accountable, but it was definitely something I've never seen used in a courtroom. With trials actually using, you can say, well, you've heard the prosecutor say X, Y, and Z, but to actually pull the clip and play it back from opening, I think it was from opening statement, I believe, certainly a pretty gutsy move. But, I mean, you know, he was holding their feet to the fire and saying, look, this is the kind of case they're bringing, and they don't have the proof.
Let's talk about Joseph Lawson for a while. Of course, he's also on trial in this case, not charged with murder, but complicity to commit murder. How did his defense attorney do today as far as the closing arguments are concerned?
I thought he nailed it. He said, quote, you probably forgot we were on trial too. I mean, and it really was a good strategy because remember, they reserved openings, okay? And what that means is that the prosecutor gave an opening statement at the beginning. Houck's attorneys, I believe Shoring gave the opening statement there. And then Lawson's attorney said, we're not going to say anything. And it was for good reason. The first week, we never hardly even heard the name Joseph Lawson. It wasn't until recently. And so they reserved, and they were able then to give their opening after they heard all the evidence presented by the prosecution on Joseph Lawson, and then present their case. He said, you know, you cannot replace outrage with evidence. Do not fall victim to that. I thought that was the takeaway, really the quote of the day for Joseph Lawson to kind of sum up their argument. You can't replace outrage with evidence. Don't fall victim to that.
Sort of reminding him this is a circumstantial case.
Right, and saying, look, you've heard all this stuff, and it's all I would say, Doug, 99% of the evidence has been presented against Brooks Houck, not against Joseph Lawson. I mean, the number of witnesses we heard, I think it may be 5 to 10% of the witnesses that maybe even mentioned Joseph Lawson. And most of their testimony had to do with Brooks Houck, though.
Going to be interested. I'll ask you this in just a little bit when we come back to you about as the jury goes off tonight and then we'll return tomorrow for their deliberations. What's the most prominent thing in their mind? And then also have 6 different questions for Nick as we'll wrap it up as we get ready to start the deliberations, which is going to be, of course, a big day tomorrow. We want to go back out to Shay in Bowling Green. And Shay, Joseph Lawson's attorneys were up first this morning for the closing arguments. They were the shorter for the two to the defense, but his attorneys called him and his father a fool.
And I'm going to bring in Alexandra Goldberg to walk us through those here in just a moment, Doug. But first, let's talk about Brian Butler. He's Brooks Houck's attorney, and he had a lot to say, literally almost 3.5 hours of testimony today, specifically, of closings, trying to make sure the jurors had reasonable doubt every step of the way. He said that the government has been guessing and making assumptions. He said that police were given marching orders to get Brooks Houck, and that's what they've been doing. He talked about how to make things work and to make the government's theory work, you have to presume that it's sinister. And you cannot presume that he is innocent. He goes through different points that he says are innocent, not sinister. One of them was Crystal playing games on her phone when they got home that night. He said that Brooks said she was playing games on her phone because that's what she usually does. He didn't know exactly what she was doing. He wasn't paying close attention. He just said what she usually does. The window tint, he said that the same day Brooks Houck made those calls about window tinting was the same day he got a text from Crystal about an upcoming eye appointment for Eli. He said it just so happens it was the week before she went missing, but the two things are not connected. He also talked about Nick Houck's phone being off. He said, yeah, it looks sinister that the phone is off for 24 hours, but really he was in a fight with his girlfriend and he didn't want to deal with her phone calls. He called the prosecution's entire case a, quote, convoluted mess. He said the timelines are all different and they contradict each other. He said all this stuff, it's just made up. And he went through again and again, point by point, of a lot of the key evidence in the case, explaining it through what he called an innocent lens instead of a sinister lens. He said when Nick Houck sold that white Buick, it was because he didn't want to raise suspicion. Tommy Ballard, Crystal's dad, had posted on Facebook, does anybody know any owners of a white Buick? This could be connected to my daughter's murder. And he didn't want his grandma's car getting seized and then his grandma to not have a car, and that's why he sold it. He said that the only reason that they were recording things is because they were paranoid. They were worried that their words were being twisted. They went from being this family with no issues, this middle-class good family that's done all the right things their entire lives, to the villains of the town, is what he said. It was the world against the Houcks. And so everything that they were doing, they were worried about it being twisted. They were worried about something being convoluted. And he said, none of this is incriminating if you put it in the light that it's not. So he really wanted the jurors to think piece by piece at all of this evidence and see that if you're not looking at it from a sinister lens, it doesn't look sinister. Now we'll bring in Alexandra Goldberg, and she'll walk you through Joseph Lawson's attorney and what he had to say.
Right, and Robert Boyd here spoke for nearly an hour. He spoke for 50 minutes, the most that we've heard him speak in this trial so far. And just to paint a picture for you about the tone that he was speaking with, he was almost appalled, pointless. Believing that it was pointless to be on trial. I mean, his first statement that he said was Steve Lawson's name was mentioned more than Joey's. His name didn't even come up until day 3. He said a quote, we didn't want to waste your time. We don't want to waste the jury's time, the prosecution's time. Almost, having this tone towards the jurors. Why am I even up here? Why is my client even here? Doug and Nick, you mentioned this too. He also said, you barely heard from us, probably forgot we were on trial at some point. Again, getting at the point there that Joseph Lawson's name was hardly brought up. Steve Lawson's name was brought up significantly more. He also said, honestly, don't know how the prosecution is going to tie this case up. It's unusual because remember the defense went before the prosecution here. So trying to, instill that into jurors' minds of that big question mark. Can the prosecution make a case here on a circumstantial case? But moving along now, one of the main points that Robert Boyd said here is he sort of paints this picture is that the Lawsons couldn't even pull this off. The Lawsons couldn't pull off a murder conspiracy. He says, quote, he would have had to trust this very important task with this father-son duo. One's an alcoholic with drug issues. He said that sophisticated businessman, being Brooks Houck, did not hire these fools to do it. Point number 3 that I'm going to make here is he asked the jurors to use that cell phone data as the North Star. So he's calling, some of these witnesses not credible, specifically Charlie Girdley and Heather Snellen, saying, please make sure you compare the witness testimony against this cell phone data, trying to corroborate his point that the Lawsons were driving on Boston Road, not the Bluegrass Parkway, that night on July 3rd. So really trying to convince the jurors here that cell phone data, when it is pinging the certain subsections of that cell phone tower, placing Steve north of Bluegrass Parkway there on Boston Road as he's trying to retrieve a car that he shared with his ex-girlfriend. And wrapping up here, I mean, Robert Boyd, again, really came at the credibility of some of the Commonwealth's witnesses, saying that Snellen and Girdley are two of the, quote, most unreliable sources I've ever seen in court. Doug.
But before you both go here tonight, what was the general feeling inside that courtroom after the closing arguments finally ended?
I will say, when I was listening in the morning to Brian Butler, Robert Boyd started, but it was less than an hour. It was easy for the jurors to pay attention to that. When Brian Butler was up there toward the end, especially after lunch, jurors looked like they were starting to doze off. They were looking a little bit bored. That one might have gone a little bit long, but Shane Young had their attention. Shane Young certainly had jurors hanging on every word.
Yeah, I would agree with that too.
Okay, thank you both. Join you again for tomorrow. Of course, it's going to be a big day starting in the morning as the jury start deliberating the case. Back to Nick Mudd, who was joining me here. A couple of points I want to ask you about. First of all, Lawson's own attorney's calling him a fool.
Right.
Does that, though, undermine any credibility he may have? I mean, we know he never took the stand and they never heard from him. So what about that tactic?
I think he called him a drunk, too, if I remember. I think it was a plausible argument, though, in the way he did it. It was like, look, Brooks Houck is a sophisticated businessman, builds neighborhoods, owns tons of rental properties, and to think he's going to trust these two who are, as Robert Boyd said, fools, drunks, and getting at a bar drinking and half drunk that night, to think that he's going to call those two to get rid of the vehicle or potentially get rid of a body, it does kind of seem preposterous. So I think, at first everybody was a little aghast hearing that, like, oh, you're even calling your own client a fool. This isn't good. But I think he made the point that, look, this sophisticated businessman is not going to hire two people unless, especially something this serious, and put it in their hands. And more importantly, he kind of put some distance when he said it between his client and Brooks Houck to say, look, we may have done the same stuff in the trial, but we're on different teams here. Whether he gets convicted, we don't care. We're trying to walk our client out the door.
Of course, the mother of Brooks Houck and Nick Houck is Rosemary Houck. She returns to the courtroom today.
Right.
When she's talked about in the courtroom today, as you just pointed out. Why do you think all of a sudden she appears today? I'm sort of fascinated by her as a figure in this case. Maybe unindicted co-conspirator.
Right, and that's what she was called. Maybe she was afraid she was going to be served with a subpoena. I don't know, but certainly it was a surprise to see her there today. But at this point, we're in closing arguments, so there's no more proof to be had. There's no more subpoenas to be given out. There's no one else to be called to the stand. Proof is done. So I guess at that point, she felt like the coast was clear, potentially.
So I want to ask you about the jury's instruction number 1 from the judge. This is on the Brooks Houck side, not talking about Joseph Lawson's case. But I've covered many trials where we thought the jury instructions, when they were given out, and we all said, huh? I mean, it seemed like it was so written and worded so confusingly. So I want to ask you about the one that the judge has put together for Brooks Houck for murder, the murder charge. You shall find the defendant not guilty under these instructions unless you believe from the evidence beyond a reasonable doubt that he is guilty of one of the more following: murder or conspiracy to murder, or murder as a principal or an accomplice, and then count 2, tampering with physical evidence. Has the judge made it easy there for the jury just to send him to prison based on one of these things?
And Judge Doug, I think the second was complicity to commit murder on that. But,
right.
But a lot of times, in my experience with murder cases as a prosecutor and a defense lawyer, usually 1 and 2 are together. If there's any thought that someone else was involved with it, it'll say acting alone or with others, and it's one instruction. The principal and accomplice, I've never seen that added to an instruction ever. And in fact, that's not what we thought we were going to hear during this, right? I mean, Shane Young came in the closing argument and said, I don't know who killed her, but I can tell you who's involved. That's not really how this case started. And it does kind of make me think, and looking at that third instruction there, principal or accomplice, that they're kind of backpedaling, and they're kind of throwing their own Hail Mary there, saying, look, okay, maybe he's not the one who did it.
Who worked to get that wording in there?
Definitely the prosecution.
Prosecutor.
Yes, without a doubt. I mean, 100%. Defense would never ask for that. I can't think of any scenario where defense would ask for that third instruction, principal or an accomplice, because it really opens your client up to 3 levels of liability: murder, complicity in murder, or accomplice or principal, or however that's worded. I mean, so again, I've never seen that third instruction. I find it strange, but again, the prosecution would have been one asking for that.
Based on the evidence as you've seen, what would a jury find him guilty of based on these 3 instructions that the judge gave him?
Well, if you go by, let's assume that they did convict him, okay? If you go by what the prosecution said, which is, I don't know who killed her, but I can tell you who involved, is Brooks Houck, it would be the third one, which is the principal or accomplice, the way that it reads, which is kind of saying, look, he was involved somehow, we don't know how, but we know he was involved, which is that third instruction, again, it's one that I'm not familiar with, have not seen.
The third one being murder, principal, or accomplice.
Correct, principal or accomplice. And so, you know, I do think when you get these instructions that are strange, if someone gets convicted, and it opens up the chance when you get special instructions like that for an appeal. So that's the danger of asking for that kind of stuff.
Okay, let's go to the flip side. Based on these instructions and what you know of the evidence, how does Brooks Houck walk out a free man sometime tomorrow night or Wednesday?
So let's assume that he's found not guilty. We'll go that route. If that happens, you know, essentially the jury, I would assume, would go through Butler's argument in closing and say, look, you know, we didn't think there was enough evidence. And I want the viewers to understand there is a distinction between he did it and he's guilty beyond a reasonable doubt. A lot of people have issues with that, and it's an emotional topic. It's upsetting, and I understand that because they want to think, hey, American justice, you should be held accountable for what you did. But whether someone committed a crime is different than whether or not they are guilty beyond a reasonable doubt. Because once you're a juror in that box, I mean, you really hold someone's fate in your hands. And, you know, jurors take that job, that duty. It's really a duty. It's American duty, seriously. And so, you know, I told you, Doug, about the trial I had where I had 12 jurors walk out and they hung, and 9 of them said, we think he did it, you just didn't prove your case. And I mean, that's a real gut shot to a prosecutor, but I went back and did the things they said and later got a conviction on the case. But that's another possibility we haven't talked about. So what if the jury hangs?
Was the jury hangs? This, by the way, is just that was page 1 I was reading of the jury instruction for Brooks Houck. This is the entire thing here. Go ahead, pick up on that. I'm sorry to interrupt.
But no,
if we get a hung jury.
I mean, yeah, and again, it does feel like a novel, and it's several. I don't know how many pages you have there, but it's several. I mean, you know, but it is a possibility that you get jurors that say, look, we're going to convict this guy. We believe he did it, but you get other jurors to say, yeah, he may have done it, but the government didn't prove it beyond a reasonable doubt. And that's where you really get the tempers flaring in the jury room. There's yelling, arguing. And I'm not saying that's going to happen here, but I have seen it happen. And, you know, I've had sheriffs say, look, I'm guarding the door, and I heard them in there screaming and yelling at each other. So it can get very tense in a jury room. 7
pages there, by the way. And here's Joseph Lawson. So let's talk about him. Like his father, he was convicted so fast.
Right.
They barely, the deliberation time was so short. What do you think happens to Joseph Lawson tomorrow?
You know, again, I start by Brooks Houck, complete coin flip. I don't know what will happen. Joseph Lawson, I mean, there just wasn't a lot of evidence presented. And I'm not saying I'm pro-defense, pro-prosecution here, Doug. I'm just saying objectively, if you look at the percentage of the evidence presented, hardly anything was mentioned about Joseph Lawson. There were a few witnesses here and there, but there was nothing really concrete. It wasn't like Stephen Lawson where we had a statement and we had him testify, right? His own attorneys admitted in opening, look, he tampered with the car. He moved, I think he said he moved the car. But we don't have that here. There's no statement from Joseph Lawson, and there's not been the level of evidence against him that was presented in the Stephen Lawson trial.
Based on these jury instructions, do you expect a lengthy deliberation tomorrow on at least the Brooks Houck case?
I do. I think the Joseph Lawson stuff, we will, you know, potentially get a verdict tomorrow with him. It wouldn't surprise me. They could take 2 hours. They could take 20 hours. I don't know, but it wouldn't surprise me if it's a very, very lengthy going through all the evidence, talking about other witnesses. Could go on for hours, could go on for a couple days.
And the judge will announce them all together. Okay, 6 questions for you before we wrap up here as we get ready for, once again, a big day tomorrow as the jury will begin deliberating in the morning in Bowling Green. Did the prosecutor present a feasible theory What about a motive? We've never heard a motive discussed in this over 10 long years here.
I am concerned about their case not having a strong motive. They did say at the beginning, you know, Rosemary Houck didn't like Crystal and wanted her gone, but that doesn't tie to Brooks Houck. So we really don't have the cheating lover, the fight over money, the kind of stuff we normally see in cases involving homicides. We don't have that kind of motive here, and I do think it does, even though it's not required, jurors still want a motive. They want to know why.
The strongest evidence presented by the prosecutor, you still believe, is the cell phone?
I think the cell phone records, I think that's the one thing that really can't be undermined by credibility. It's strong, it's scientific, it's fairly, for the most part, pretty objective. Obviously, we saw Robert Boyd poke some holes with his client with cell phone records, but in terms of Brooks Houck, I mean, those records speak for themselves.
How did Houck's lawyers handle this timeline, their general theme and the strategy of what they went for here, which was really to poke holes in everything that was said, including the, I thought this was interesting, the cadaver dog that came in.
Right.
Brian Butler said this about the cadaver dog that had a hit on the back of that Buick, Anna Whiteside's Buick. He said they had resources unlike I've ever seen in 30 years, he's telling the jury. They had access to FBI dogs, KSP dogs. They found this guy at the NRA fair.
Right. I think, you know, I was curious how Butler was going to handle the timeline and closing argument. He essentially went a direction I didn't really consider, which is just saying, look, the timeline's a wash. It's a mess. We got people saying this, people saying that. It's like if you look at the cell phone records, then you look what other people say, nothing meshes. And that is reasonable doubt. When things don't line up, when the testimony and the cell phone records don't line up together, you can't hold my client accountable, is essentially what he's saying. I think he even stated, it's a mess.
But don't you remember, I remember when we had the day come along where the 8-page written statement was detailed there that Brooks Houck took an hour and a half to write, and then they brought witness in after witness in. We thought that was, we thought at the time that was a big day for the prosecutor.
It was, but you know, you got to remember though, you can be a liar and not be a murderer, all right? And I think that's what the defense Butler harked on today a lot, which is like, look, he gave a statement, but it wasn't entirely inconsistent. I mean, he gave some explanations, albeit weak, but again, Shane Young did a good job of saying, you know, the statement he gave is complete nonsense, and this is why we called all these people. And, you know, that's ultimately shows someone's guilty.
Final question for you. What's exactly going to happen tomorrow? Take us through daybreak on when they come together, and what do the jury deliberations look like? What are we going to see in the give and take, and when we can possibly expect a verdict? So
generally what will happen, the 15 jurors will be brought in tomorrow. The judge will read the law to the jurors. 3 will be random, that's the jury instructions. 3 will be randomly selected to be removed from the jury. They will not deliberate. We don't know what 3, they don't know what 3. They're all coming back tomorrow. At that point in time, the judge will hand the jury instructions to the jury, have them go back in a room. Normally what they do is elect one person to be the foreperson. It's not, I've never been in a jury room, but certainly I ask a lot of questions after trials of juries. Normally what they'll do is kind of take a straw poll back there to see where everybody is. And then, you know, depending on the makeup of where that lands, that's when they start back the evidence. You know, you get somebody that's guilty, we want to know why. You get somebody not guilty, we want to know why. And that's where they really, you know, kind of break it down. A lot of times I've had jurors come out and say, we want to see testimony from this person. We want to see Charlie Girdley's testimony again. We want to see the tape from Brooks Houck again. We want to see this or that. That would not surprise me if that is requested over the next 48 hours at some point.
I will say that nearly every time I've tried to predict a jury and read them, 99% of the time I've been wrong. Do you want to make an effort here tonight to predict what happens tomorrow?
I think Brooks Houck is 50-50. I mean, I have no idea. I don't. I mean, I think the prosecution presented their best effort, but again, it's a question of proof beyond a reasonable doubt is a very high standard, okay? And that is a different standard than asking the question, do you think someone did it?
If you have reasonable doubt, you cannot convict.
Correct.
Okay. Now, tomorrow, follow WHAS 11 News. Stay close to us. Our excellent blog is right on the front page of WHAS11.com. That information is coming from Shane McAllister and Alexandra Goldberg and WHAS 11 digital journalist Joseph Garcia, keeping it up to date for you every time we get a break to be able to bring you information. Tomorrow's going to be, the information is going to be flowing as quickly as possible because we are not held into the courtroom. We'll be able to tell you about any movement we see outside the courtroom and how things are going along. Again, that's WHAS11.com. As again, the closing arguments will get underway at Bowling Green in the morning, and then we'll be on the air for any special report coverage for you right here on WHAS TV and WHAS 11 Plus live streaming. We'll be right here with it when we get a verdict, and then back here tomorrow night for a 30-minute wrap-up, possibly even longer if we have a verdict on WHAS 11 Plus. I'm Doug Proffitt. Thank you very much for watching. We'll see you tomorrow.